That His Excellency John Dramani Mahama. Ninso wadi ko down mo say afi 2020 general elections e course so e wo man Ghana no niam bi antwa ye ndi yenhwe na nkabato no yensan ento no fofo nanso next Supreme Court e kwa asetena no mo chese opani no oni nyina so bia nti asem no wo mo abo agu Chief Justice ra anim yebo a ene kasae.
On this issue, we are settled in our minds that the allegation of vote pardon, though serious in an election such as the presidential election, was not proved by credible evidence. Furthermore, even if the vote pardon took place, same was not material or substantial to change the final results, so declared by the chairperson of the first respondent. In holding that the impact of the vote pardon, if even proved, could not have affected the declaration, we are emboldened by the decision of Lord Denny in the case of Morgan versus Simpson, 1975, 1 Queen's Bench 151, which was cited by counsel for the petitioner in his closing address. We observe, however, that counsel for petitioner only referred us to only one of the three propositions articulated by Lord Denny. In that case, Lord Denny summarized the duty of courts in making declarations upon hearing election petitions. He stated three propositions as follows. 1. If the election was conducted so badly that it was not substantially in accordance with the law as to elections, the election is vitiated irrespective of whether the result was affected or not. 2. If the election was so conducted that it was substantially in accordance with the law as to elections, it is not vitiated by a breach of the rules or a mistake at the polls, provided that it did not affect the result of the election. 3. But even though the election was conducted substantially in accordance with the law as to elections, nevertheless, if there was a breach of the rules or a mistake at the polls, and it did affect the results, then the election is vitiated. When Lord Denny's propositions are read as a whole, the combined effect of the propositions is that an election will be voided upon the occurrence of infractions that actually affect the votes of the citizens cast at the polling stations, and not the incidents of administrative errors and or mistakes committed by officers charged with the conduct of such elections. We find this same sentiment expressed by our own eminent jurist, Adinyira JSC, in the first presidential election petition case, Akufo-Addo and others versus Mahama and others. The first respondent affected the validity of the declaration made by the chairperson of the first respondent on the 9th December 2020, as already stated in this judgment. The petitioner has not produced any evidence to rebut the presumption created by the publication of CI 135, for which his action must fail. We have therefore no reason to order a rerun as prayed by the petitioner as in relief F. We accordingly dismiss the petition as having no merit. By court, the petition is dismissed as without merit. We make no order as to cause.
All rise.